High Court ruling reaffirms RAF's liability for medical costs, unpacking the implications of the Discovery versus RAF judgment. In a significant legal development, the recent judgment by the Going Division of the High Court in Pretoria reaffirmed the Road Accident Fund's obligation to cover past medical expenses for road crash victims, despite the legal challenge from Discovery Health. This ruling has drawn substantial attention due to its implications for medical aids and their members. The ruling, delivered by Judge President Dunstan Mlambo alongside Judges Noluntu Bam and Ingrid Opperman, emphasized that medical schemes like Discovery Health might require their members to reimburse them for medical costs recovered from the RAF. However, these schemes have no legal grounds to claim expenses directly from the RAF, a clarification that retains the status quo. Prof. Hennie Klopper from the University of Pretoria provided expert insight into the case, underlining that the RAF's statutory and common law obligations to compensate victims for medical expenses remain intact. According to Klopper, the legal battle primary highlighted the perennial issues of RAF's operational efficacy and its direct impact on victims awaiting due compensation. Emerging from this ruling is a clear delineation between the responsibilities of medical aids and the RAF. Medical aids can continue to require reimbursement from their members after they recover their medical expenses from the RAF, but they cannot directly claim those expenses from the RAF. Moreover, Gert Nell, a representative from Gert Nell Inc. attorneys, criticized the RAF's management, indicating that operational inefficiencies continue to hinder the execution of its mandate. He pointed to recent regulatory changes which he argued have made it more cumbersome for victims to claim compensation, thus negating the intent of the RAF Act, which seeks to simplify and expedite access to funds. Aside from legal interpretations, the RAF CEO Collins Letsoalo's response to the judgment was notably triumphant, terming it as a watershed for South Africa and the RAF. This indicates the fund's relief at not having added financial burdens imposed by medical schemes' direct claims. In his reaction to the RAF's stance, Discovery Health CEO, Dr. Ron Whelan, expressed his organization's intent to appeal the judgment. Despite the proposed appeal, legal experts suggest that an appeal may not be necessary as the judgment doesn't change the fundamental dynamics of how medical expenses are recovered post-road accidents. The unfolding discourse post-ruling reflects a broader debate on how road accident victims are compensated in South Africa and the roles various entities play. It is emblematic of the struggles within the systems established to support victims of road accidents, where legal, operational, and bureaucratic challenges collide. As the RAF, legal experts, and medical schemes interpret and adapt to this ruling, the paramount focus should remain on ensuring that road accident victims receive timely and fair compensation. This case serves as a reminder of the intricate balance between legal frameworks, institutional responsibilities, and the urgent needs of individuals recovering from road accidents. Thank you for choosing Satori News.